Appendix B1. The last paragraph, the conclusion, that the patient is a 55-year-old female with known hypertension and multiple breast masses, paranasal sinusitis, vertigo, and post-traumatic stress. According to the assessment by the resource doctor, the doctor says assessment and monitoring the progress of the mark of breast masses is beyond the capacity of the prison health services, beyond the capacity of the prison health services. These are very, very serious ailments, breast masses. Lord, all of us be interested in the accused being available, not only for the trial, but after the trial. For more reason why we pray our Lordship to grant her bail. After 5 years in the past, this court considers such an age as extreme old age. The jurisprudence of this court in the past. Advanced is extreme. No, you are not advanced. I know that you are not.
You say that 55 is advanced.
Yes, advanced.
Old, as extreme old age.
Well, the authorities are there, my Lord, in our submission. Their lordships before you have made such a decision. My Lord. No, the prayers, of course, as I said, the prayers are as indicated in our submission.
We should highlight a few things before you can lodge. Relating to some of the new evidence that was adduced to the joinder and the documents that were presented, the sureties and the successive.
Thank you, my God. My name is Rebuttal. Lord, we will briefly highlight our responses as presented on record already. My Lord, we bring it to attention that this is a third bail application being brought by My Lord, there are no applications applications is settled, the applicant may be at liberty to bring as many applications as possible. However, each application has to be considered on its own merit, and each application should be regarded as independent of the other. It is for that reason that, my Lord, each application is given a unique number and one application cannot and should not be used to review the previous one. The merits and demerits in one application cannot also be used as a point of review in the current application. My Lord, in our application we drew the attention of this court. In our response, I beg your pardon, drew the attention of this court, my Lord, to the decision in criminal miscellaneous application number 74. Criminal miscellaneous application number 74 of 2023 of Leo Simon Peter and another versus Uganda. My Lord, that authority discusses the Indian Supreme Court authority of Karyan Chandra Karyan, my Lord, as K-A-L-Y-A-N Chandra versus Rajesh Rajan. Lord, the citation is in the submissions. The point we want to emphasize is that, as held by your brother Judge Justice Philip Odoki, which holding, my Lord, we invite you to be persuaded to follow, because it appears to be the locus classicus so far in the jurisprudence of Uganda on successive applications. The requirement is that there must be a change in a fact situation or in law which requires the area review, the area view in the previous application to be interfered with. And that without change in circumstances, the subsequent bail application would be deemed to be seeking review of the earlier and successive application. My Lord, the applicant first brought High Court miscellaneous application number 52 of 2024. Which application was heard and dismissed. She subsequently wrote High Court miscellaneous application number 93 of 2024. My Lord, the second application was heard and dismissed, among others, on the grounds that it was presenting the same grounds as in application 52 of 2024. And there was no new ground. So the highlight that we want to make, my Lord, is that the current application number 513 2024 is cover premised on the same grounds as the first two. In fact, my Lord, also premised on exactly the same documents. Exactly the same documents. Save, my Lord, the new ones that have been introduced this morning, for which we shall read. So on the basis of that ground, there are no new issues being introduced, no change in circumstances. Invite your Lordship to dismiss the application for want of merit. Having highlighted that, my Lord, we briefly want to touch on some of the grounds first being medical. My Lord, the health, if health is to be used as a ground, then there must be evidence in the current condition. And what you have in this application are medical documents of about 1 year ago. That were not only used in the previous day applications, but also that don't speak to the current medical condition of the applicant. My Lord, the only attempts to explain the condition of the applicant was done by the deponents, both myself in support of the notes of motion and the rejoinder. My Lord, none of those deacons is an expert in the medical field. And any attempt, my Lord, to explain the medical condition of the applicant through submissions by counsel would be at most hearsay. As the same would not be sufficiently supported. So we emphasize that section 16 of the TIA requires certification of the applicant's medical condition by a medical officer of the prisons. As of now, my Lord, as of now. My Lord, Annexure E. Annexure E to the applicant's affidavit is a report that was authored on the 8th of February 2024, my Lord, 1 year ago. And all the other 3 medical forms, my Lord, in the interest of time, are also dated about a year ago. With the latest, and the latest, my Lord, of all the medical forms is the one authored by Dr. Kisambu James of Luzira Prison, and it is dated 15th of April 2024. And my Lord, in that report, Dr. Kisambu was reviewing an earlier report by a team of consultants from Mulago Hospital. Dated 8th February 2024. My Lord, there are 2 things to highlight in this report. First, technically speaking, Dr. Kisambu as a single junior practitioner my Lord, their titles are indicated because the team from Mulago is a team of consultants, and Dr. Sam is not a consultant. Even if Dr. Sam was to be at the same level with the team of Mulago, a single practitioner, my Lord, cannot review an expert opinion of 3 consultants. A report of 3 consultants can only be reviewed by a team of an equal number or more. That is the first observation. But the second observation, my Lord, is that the report we purported to review observed the same condition, breast symptoms, and gave a clear treatment plan. Lord, if you consider that report of 8th February 2020, gave a clear treatment plan. All the medical attachments do not speak. All the medical attachments do not speak to the current condition of the applicant as required of this court as being suitable to explain the current medical condition. My Lord, finally, we want to comment on the sureties. My Lord, as we noted, every application is separate and distinct from the other. And to be determined on its own merit. My Lord, the recommendation letters, which we had received earlier as annexed to the application, that from next year's G2 to K2, the applications, it is only 2 sureties have given LC recommendation letters which are current. We want to begin with Mr. Geoffrey Cameron, my Lord. My Lord, you will note that the new recommendation letter of Mr. Geoffrey Cameron dated 12 February 2025 is handwritten and word for word as the content of Annexure I I2. My Lord, annexure I2 is what was previously used in application 93. And also annexed the current one. My Lord, there is something more important. Word by word, but my Lord, it does not require even the aid of a handwriting expert to know that there are two different people authoring these letters. My Lord, the authors are also different. And I invite you, my Lord, to look at I2. In I2, which is annexed, my Lord, there are two authors. That is Muhanji Ronald, who signs out as the secretary for the LC area, the general secretary for the LC. Now, in this current application, my Lord, the author, who also claims to be general secretary of the same LC, has different names. That is Auma Barbara Wandera. Signatures are different. Even the telephone numbers are different. The stamp which is being used on the current recommendation letter that is being authored by the secretary is for the chairman, the chairperson. So a strange general secretary, different from the earlier one that is on record here, my Lord, in the same application is using a stamp of chairperson. And whereas in I2, the chairperson also signed, somebody signed as chairperson. In the current recommendation letter, there is no indication of chairperson. I wrote so that I do not come back to on Mr. Kamu. We also object to his suitability as surety. And we invite your Lordship to consider the affirmance in our affidavit, our supplementary affidavit in opposition, informed by Detective SP Viviana Acom. I wrote specifically in paragraph D and E. I wrote in those paragraphs, we demonstrated that Mr. Kamuntu has a history of obstructing the course of justice. For which the Republic of Uganda is investigating him in the criminal case highlighted in paragraph E. I know you will not in the rejoinder, the affidavit of rejoinder, Council Augustine Abirir E. Dot tries to explain and justify the suitability of Mr. Kamu. But, my Lord, with due respect, he is not competent to speak for Mr. Kamu, because the issues as to his credibility as a person can only be explained by himself, and the applicant did not deem it necessary for him to depone, to rebut. Meaning that the averments of Detective Viviana are not rebutted, and they remain unchallenged. And finally, my Lord, on Mr. Kamu, the submission that the previous rulings found him substantial, my Lord, is not true. Because in the previous ruling, the court only suggested that they appear. The court never indicated that the sureties are substantial. His Lordship says that sureties appear substantial. And His Lordship, in the previous ruling, my Lord, also did not make mention of the personal antecedents brought out by Detective Viviana. My Lord, on the second surety, who was presented as the first surety, that is Dr. John Patrick Caballo, I'm sorry. My Lord, for Dr. John Patrick Caballo, of course, the H2 was their first letter, my Lord. Dated previously on the 14th of April, 2024. There has been an attempt, my Lord, to cure the dating by filing the current letter dated 11th February 2025. But my Lord, when you look at the two letters, they raise very strong suspicion as to whether we are dealing with a legitimate local council authority. My Lord, the letter of H2 is not on letterhead, and the letter of this morning is on letterhead. But the writing, my Lord, the typing is word for word as the previous letter. That's the conviction, my Lord, should not be taken lightly. But we also want to highlight Mr. Kaboyo going by his, if I may have his ID again, please. He's a born of 1948. In fact, my Lord, this is the true reflection of, and with due respect, extreme advanced age, as opposed to the applicant. Because he is a senior citizen of 76 years, 77. Now, my Lord, a person of extreme advanced age. To be burdened by the laborious duties of surety.
Is he a person in some sort of authority or a respected member of the community that can control the applicant? I don't think that much of it. Sorry, I'm now hearing it.
Well, I'm most of that, my Lord. I'm most of that, my Lord. Because I was just highlighting the fact that if at 55, the opinion of the applicant is that that person is really extreme, then how would you burden the one that is 20 years older? But I am most obliged. If they feel that it is strong enough at that age.
And so he's not going to be required to carry this person. And so it's something you think it's relevant. And that's your submission.
We are most obliged. And my Lord will make that submission with due respect, Mr. Kapoor. Then the third proposed issue, my Lord, General Emmanuel Burundi, my Lord. His recommendation letter, my Lord. One was last year,
My Lord, just as a point of apology on that one, I think I handed over a wrong one maybe. I think you can make the submission on that one.
My Lord, we can graciously accept the present one. Our colleagues invited.
Neno jambo fulani.
But my Lord didn't intercard.
Haina kamera. Haina kamera.
First of all, the current one is still word by word as J2 annexed the application. My Lord, these applications are handwritten, and it is not humanly explainable that two authors, or even if it were the same author, would by their own hand author two different letters a year apart. And each of those letters, my Lord, is word by word, where there is a full stop, where there is a comma. This is not a normal way of life. But even then, the author of the current letter, my lord, which the applicants framed beyond record, they indicate the name of the chairperson as Rechezi Godfrey, but it is being signed on behalf. There is a PP, my lord. The last I checked, PP means on behalf, and the one signing is not reflected. But also, my lord, as you will note, the letter is even addressed to the Chief Magistrate. Chief Magistrate, High Court, Kampala. My lord, the last I checked, there is no such authority in the structure of the judiciary. My lord, this is not, should not be treated as a minor omission or error, because these applications are processed by lawyers, by writing word by word. It means this person is really very careful as to the business. If I may just finally have the ID of Mr. Brody. So, my lord, this attempt to cure the back, the old letter even raises more questions of credibility, especially for serious application. So we highlight and submit that LOC letters should be specific, and capable of introducing the proposed surety without raising questions of credibility. So, my lord, our final prayers in our submissions. We pray that this application be denied for the reasons contained in our objection. We emphasize that the main case, my lord, is in advanced stages of hearing. With 10 witnesses so far of record. The trial is on course and there is no likelihood of delay. In fact, my lord, this is one of the most fast-tracked capital trials that have had the benefit of undergoing hearing in under a year. So pray, my lord.
The applicant is accused of this case, Mrs. More Katanga. is attending by way of IT connection from Uganda government. There she is.
Copy, my lord, is attached to the application.
A copy is attached on the original. In reply, my colleague, Mr. Katanga, we appreciate forward by Mr. Magega.
If it pleases my lord, for the record, I'm Ellison Karuhanga. My lord, I will reiterate the submissions made in rejoinder. But my lord, briefly, my learned friend has in his words, a locus classics. My lord, we submit that the decision in Appeal Simon Peter was actually a decision made by Curia. The overriding consideration in a bail application was determined by the Supreme Court of Uganda in the case of human rights, a Foundation for Human Rights Initiative. Versus the Attorney General, which was Constitutional Appeal number 3 of 2009. Where the right to make an application for bail, the court said that there not binding in this court. We submit it shouldn't even be persuasive when there is binding authority. Nonetheless, my lord, as we have submitted, and I will not delve too much into the submissions, the stage at which this trial has reached have substantially changed even the circumstances of the trial. The prosecution has led its witnesses and they cannot be interfered with. My lord, you are taking over as a new judge in this matter, and therefore there is a lot of time that will be required to go through 7 volumes of the proceedings, more than 20 exhibits, and my lord, we've highlighted all of this. My lord, still on the same argument, my learned friend then rushed into saying that the medical reports are the same. And based on no evidence whatsoever, claim that Dr. Chisambu, the Commissioner of Health Services in prison, is junior to the Mulago doctors. My Lord, while it's actually not based on any evidence, and in fact it's probably untrue, but even were it to be true, it's the very ground on which the applicant should be released on bail. There are no senior doctors where she is. But my Lord, I wanted to correct a few misconceptions that were given about Dr. Chisambu. He said Dr. Chisambu simply performed a review of the medical report. My Lord, an extra E1, which is Dr. Chisambu's report. Paragraph 2, and I beg the indulgence of court if I can it's just a very short sentence. If I could just read it for you, my Lord. The learned doctor, my Lord, says that in view of the medical report provided by Mulago National Referral Hospital, a follow-up medical evaluation was conducted at Luzira Women's Prison. So, what his report is giving us, apart from paragraph 2, the heading of his report is Medical Examination Report for Mrs. More Katanga. So it's not correct to say that Dr. Chisambu was reviewing the report. He was actually looking at the patient. And my Lord, it is worth highlighting. My learned friend then said that there was no difference between the Mulago report and Dr. Chisambu's report. I know this is also a mistaken reading of both reports. I know the mixture E2, which is the Mulago report, just on the issue of breast masses, at page 2, says breast examination revealed, quote, cystic mass in the left breast upper outer quadrant, close quote. So in February, she was found with a cystic mass in her left breast upper outer quadrant. That is A, which my Lord is singular. Dr. Chisambu, on his part, says, on examination, she was found with, quote, multiple fibrotic masses in the right upper quadrant of the left breast. The one problem had started multiplying. And he concludes, my Lord, by saying that his ability to assess and monitor, quote, the progress of multiple breast masses is beyond the capacity of prison health services. So just as a point of correction, is not correct that he was simply reviewing and saying, as before. But another friend is saying that if you are sick and the hospital has found that it can't treat you, it should keep releasing new reports for bail, that every subsequent bail application the fact that the doctor has said you have PTSD, hypertension, vertigo, and multiple breast masses. The fact that each time he must issue a new report, and that new report equals a change in circumstances. Is not only not supported by authority, but it is actually a fundamental affront to the principles guiding bail and the presumption of innocence that were established in the Foundation for Human Rights case. My Lord, the medical condition of an applicant must not keep worsening. You must not come and argue that you are not yet bad enough, because then pre-trial detention becomes a punishment. It becomes a sentence. Then trial detention becomes a sentence. My learned friend talked about the speed of the trial as a record trial. I know there's nothing speedy about 15 months. My Lord, regarding her health condition, the applicant has herself deponed in her affidavit that she's unable to stand properly on account of vertigo. My Lord, my learned friend then spent a substantial amount of time on the form of LC letters, and particularly on the suitability, firstly, of Mr. Kamuntu to be a surety, and then the affidavit in rejoinder, for which she said Mr. Kamuntu was being spoken for. Again, my Lord, if I can just point out that the affidavit opposing Mr. Kamuntu is a regurgitation of a previous affidavit. At page 2 of the affidavit in rejoinder, the impugned paragraph, my Lord, with your permission, if I could just highlight it. This is paragraph 2E. The affidavit in rejoinder sworn by Augustine Obili Idot, the lawyer for Mrs. Katanga. He says, and I quote, regarding Mr. Geoffrey Kamuntu, I note that the allegations against him were previously raised in earlier bail applications and were found to have no merit by the Honorable Court. In fact, the court ruled he was a substantial surety for the applicant. A copy of Mr. Kamuntu's previous affidavit and the ruling affirming his credibility as surety are attached and marked C and D. So the rebuttals are of the exact same things are contained again in Annexure C, which is an affidavit of Mr. Kamuntu. And that is a 20-paragraph affidavit. I will not go through that affidavit in any detail, except to point out that it thoroughly rebuts with documentation the allegation. But my lord, what is important? This is an affidavit which was sworn in April of 2024. What is important, my lord, is paragraph 11, that he has never been summoned for that alleged obstruction. But my lord, even without a reply, the presumption of a court of law is the presumption of innocence. The prosecution should have said he has never been convicted. But allegations for which you have never been asked to explain, for which no charge has been preferred, for which no trial has been commenced, can be used as the basis. My lord, briefly, what is important for the surety is that he must be of sufficient authority to ensure attendance of the accused person at trial. But Mr. Kamuntu's, the issues of Mr. Kamuntu are really that he was even the next of kin when the applicant was in hospital. And that he's a relative and a cousin of the accused person. My lord, now I want to go to the issue of the LC letters. My lord, this court is not reviewing the suitability of the LCs. It is reviewing the suitability of the sureties. Maybe, my lord, if I could have those letters. My lord, I want to start with Dr. John Patrick Karai. And I think the objection to his LC letter if I understood it, was it is similar, word for word, to a previous letter raised. The letter says, my lord, that he has lived in the area since the 1980s. Owns 200 acres of land. Was the area member of parliament. Represented the area in the Constituent Assembly. He is widely regarded in the community. He is a senior citizen. He is her uncle. The objection to this letter is that it says exactly the same thing as the one before. My lord, the court can take judicial notice of the fact that John Patrick Karai was indeed a Constituent Assembly delegate. That he was indeed a member of parliament. Just like we know that was also. By way of example, that he owns 200 acres of land, that he manages coffee, bananas, mangoes, passion fruits. The applicant, my lord, is saying that Mr. Cavallo is her uncle, her paternal uncle. His age shows that indeed he is much older than her as her uncle, a responsible member. The court observed him extremely fit, while his face looks 78, his body looks 40. As opposed to the applicant, my lord, who while younger, because of disease, is frail and injured. So, my lord, the court cannot reject the substantiality of Dr. John Patrick Cavallo on the ground either of his age or of the fact that his LC used a precedent to draft the LC letter. My lord, our LCs are ordinary people. Their letters will contain errors, their letters will contain certain mistakes, but the point is, they confirm he is their resident and a leader and an elder. And his relationship with the applicant is that he is a substantial surety. My lord, regarding Mr. Kamuntu, I think the argument was that the person signed as General Secretary LC1, stamped as LC1 chairperson, and again a previous letter was written. And again, the contents of the letter are that since 2016, he has been living in that area as an owner of his own property. Again, my lord, we are not judging the LC system. The police always had the capacity to go and check with LCs and see if they are genuine LCs. Even for the ones who were there, for the letter there. But by not even that beside the point. Again, that Mr. Kamuntu, an next of kin, a businessman, a property owner in an area, would be judged on his own basis as a surety. My lord, again, the objection to General Burundi. Seems to be that his LC wrote to the Chief Magistrate High Court. My lord, the affidavit in support of the application again, which has not been contradicted, shows that Major General retired Emmanuel Burundi and Mansa apart from being the applicant's relative, is a retired 3-star general of the UPDF, 2-star, the retired 2-star general of the UPDF, a retired diplomat, having represented Uganda in diplomatic service, a cousin of the applicant, and her immediate next door neighbor in Chwatu Road in Buya. That's a substantial surety by any measure. And the measure of this substantiality cannot be the civics knowledge of the LC1 chairman, who doesn't know that he's the chief magistrate of the High Court. My Lord, bail applications, as we submit and in summary, before I allow it very next to final point. My Lord, bail applications are simply supposed to be whether the accused's attendance at the trial can be confirmed. It is not to be denied, my Lord, on the basis of every technical and flimsy ground. Bail ensures, my Lord, that an innocent person is not punished before conviction. What is being sought, my Lord, is punishment without verdict, is suffering without judgment, and is a prison sentence imposed by the machinery and sophistry of a trial. My Lord, this is finally, and I'll say this and hand over to my learned friend, Mr. Kabeka. And my Lord, the purpose of the decision in Foundation for Human Rights Initiative. No, maybe my Lord, I'll make 2 points, then hand over. The purpose, my Lord, is not to make the trial a game of endurance. It's not to measure how long she can endure. But it's about upholding the cardinal principles: the presumption of innocence, the right to a fair trial, and the fundamental dignity and worth of the individual. My Lord, we have detailed all of these in our submissions, and even the peculiar circumstances of this case, my Lord, that in their own summary of evidence, the prosecution says that from the events which led to bringing us here, the applicant was grievously injured in the quiet confines of her bedroom. And her health is a result of the injuries sustained on the 2nd of November. My Lord, the applicant poses no risk to the society, no risk to the community. And there is no reason why, for the remaining part of her trial, she cannot be allowed to conduct her defense. As she is treated and in the sanctity and privacy of her own space. My Lord, the applicant, as we have said, is a mother of an infant of 11 years of age. My Lord, I'll now, that did not come up, but my Lord, the antecedents, it did come up in their submissions, but my Lord, is in our, I'm just highlighting it, it's in our submissions, and my Lord, allow me at this point to allow my learned friend Mr. Katanga to wind up and to give greetings from myself to someone.
Very brief, simply in addition to what my submission of the phrase. My Lord, I want to first give you the issue that was raised by my land when we started to understand regarding the report by Dr. Sambo, where he made an attempt to break down my Lord. But my Lord, I want to refer you section 15, section 3 of the TIA. My Lord would say, if I may, that in this section, circumstances mean any of the following. A, grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody. What the law requires is medical examination by a doctor where the applicant is being detained. This is a doctor, my Lord, who has been attending the applicant, examining her, and the one who made this report. And the conclusion of this report, my Lord, is on the last page, 55-year-old female, non-hypertensive, multiple wrist masses, rhinosinusitis, fatigue, and post-traumatic stress disorder. Assessment and monitoring of the progress of the multiple wrist masses is beyond the capacity of the prison health services. And Lord, in my submission, that is regulated with this medical officer that is finding too that they cannot now manage the applicant. And this is in accordance, my Lord. Secondly, my Lord, I want to turn to the full affidavit, right? First to the affidavit owned by grand sister here. Paragraphs, starting from paragraph 20,
that evidence will be in respect of what point you submit. Because we never made mention of that evidence at all. So even a mere mention of it in the rejoinder opens new issues that we don't want to waste notice.
My Lord, I'm not blind to his submission. I want to restrict myself strictly to his submissions. My Lord, the point at which I want to make, if I may now for the sake of my argument, is the fact that relating to the where I submitted that whatever is presented in this application is not new. Rather, these are matters which had been dealt with in the previous two applications.
So you're raising a new
The
matter?
matter
You're pointing out a new matter?
This is what I want to point out. My Lord. Now, this is what she says. Wait.
You're responding to his submission that there are many matters. So are you in reading what alkeys are referring to? Are you addressing the new matter? Are you showing that there is a new matter?
Yes, my Lord. And I want actually to show the court that our affidavit has material paragraphs which are false.
No, never.
Wait, please wait. Please, Mr. Wakanya.
So let him speak and if you point out the objection.
In paragraph 7, my Lord, this is what she says. Roman 1. All the attached medical documents have been considered by this court in the previous bail applications and found not to be restrictive. Now, the submission, my Lord, I want to make is that this is partly false, in the sense that when my line friend Mr. Mwaka submits that everything, that all the medical documents submitted were dealt with in the previous two applications. That is partly false. My Lord, if you look at the two applications, the last application, there are two applications mentioned. One is 2024, and the other one is 093 in 2024. My Lord, the application, the last application was decided on 9th April 2024. This court, E1, is dated 15th April 2024. So the court would not have considered this application, this report, after it had made its rule.
Was that report considered in the second application?
No.
Was it considered in the first application?
No. Yes. As you can see, it is dated 15th April 2024.
Madam, we have to receive it on this point. The first bail application was decided on 9th of April 2024. And the second application was decided on 21st of May 2024.
So in the one of 21st of May,
Yes.
was that report considered?
Yes, madam.
Was that the next?
It was an annexure and it was considered, my lord, and that is what Mr. Morgan was referring to.
Perhaps you submit on something else.
No, what I want to submit on my own is that even then, the condition has not changed.
That's not changed.
The condition of her health status
Has not changed.
has not
That
changed.
is what he stated, that there is no new circumstance. And then he already addressed it in his submissions.
And we have to be
Yeah.
as much as possible.
Now, my lord, regarding the submissions on the documents by the various students, my lord, in line with the bail guidelines, the practice is that all documents that are going to be used in application must be given to the other party. And the purpose of that, my lord, is to give time to the other parties to verify their authenticity or not. My lord, in this case, the prosecution has not brought before court any evidence to show that the documents are submitted at the time of the application. That they are doubted at all. Counsel cannot simply stand at the bar to address court and say, oh, this one was not signed by the same individual, and yet that is what you ought to have done before. So in light of that, my lord, the documents are submitted by the sureties, generally, and then the court finds since there is nothing but that in any case, the court documents are not entitled. Lastly, my lord, on the surety and support law, if you come on, there is paragraph 3E, and that of my hand sister, paragraph 'Diana, where she advised that investigations in the main case of YIHK guard police post SD 1412/12/3. This is paragraph 3E. They said Godfrey Cameron, who is being presented as a surety in this application, is under investigation for obstructing the police from doing their lawful duty in relation to the investigation of the main case by IHK that police post SD. Right. I know, other than that plain statement, there is nothing to show that the case has ever been prosecuted. In any case, as it says, this post station diary, they simply make a report there. They have not taken it up beyond that. So that is not something my Lord we should use against you. I conclude that is not a substantial surety. I don't think I should go into that. Reiterate. The applicant being raised. Or maybe, I don't think so. In fact, paragraph 14. Council. No, anarchism. Paragraph 14. It says, I swear this affidavit will oppose the release of the applicant bail, among others, to allow the case to be expeditiously determined. Installments. My Lord, my submission is that the fact that an accused is allowed granted bail and not or could not in itself curtail expeditious trial case.
Okay. Predefined.